Keith Whittington. I'm a professor of law at Yale Law School, and I want to speak with you today a bit about freedom of the press. In particular, I want to talk about freedom of the press as it applies to social media. So social media, of course, is a very new technology, and it's raising interesting new challenges about how to think about the relationship between the First Amendment, government regulation, and how social media operates more generally. We have some guideposts to help think about this that exist from how the court has talked about freedom of the press in other contexts and with other technologies, some of which are somewhat analogous to social media, some of which are pretty different from social media. And so we can learn lessons both from things that are similar and also from things that are different from the social media context. And moreover, the government has created a particular framework of regulation around social media that helps construct the social media environment that we're operating in. And that raises questions about, well, the government's regulating social media to that degree, how much further can they go? And so we want to talk through both that government regulatory framework and also the First Amendment implications that surround social media more generally. But one starting point for thinking about this problem begins with a very basic question of what's called state action doctrine. This is the question of what do constitutional rights apply to in general? So you as an individual have a constitutional right to engage in freedom of speech or freedom of press, for example, but who is that right protecting you against? And as we traditionally understand it in the United States, constitutional rights apply against government officials, not private entities. So if we take the language of the First Amendment, for example, Congress shall make no law abridging the freedom of speech. That's a specific limitation against a particular governmental entity about your freedom. Congress shall make no law abridging your freedom of speech. But that doesn't protect you against private entities and the ways in which they might try to restrict speech in general. So we think about the way the First Amendment works, the way constitutional rights work in general. The government is limited in how it can restrict speech, but private businesses and organizations are not. And in the social media context, that means in particular, the social media companies as private companies are free to engage in content moderation, for example, to restrict what kind of speech is published on their platforms, to kick people off of social media so they cannot publish on their platforms at all, in ways that government officials can't, because private businesses are not constrained by the First Amendment. Now, private businesses might choose to voluntarily constrain themselves to very similar principles. So they may adopt a content moderation standard that looks a lot like the First Amendment. So they may guarantee you something that looks a lot like constitutional freedom of speech on their platforms. But that's a voluntary choice that they made. They can choose not to comply with that standard anymore, to adopt a completely different standard. They get to choose their own rules about how to implement that standard without worrying about what the government itself might do. So there's a very important distinction to start from about what government can do and what private businesses can do. But when we think about how government regulates the media, that includes social media, but also includes traditional media of various types. And the government and the court has thought about what the First Amendment implications are when thinking about the freedom of the press relative to media companies in various ways. And one starting point is thinking about media monopolies. So if a media company is forming something like a monopoly, and the government in general can regulate monopolies in various ways, does the First Amendment create special protections for media companies that don't apply to other kinds of companies about what kinds of interference the government might make into the operations of the government? And the court was confronted with that in the case called Associated Press versus United States in 1945. And Justice Black wrote the opinion for the court in that case. Justice Black was particularly famous for his robust understanding of the First Amendment and the kinds of protections that included. But even Justice Black thought that those kinds of robust protections for the First Amendment did not extend to thinking about the problem of media monopolies more generally. So as Justice Black said, the First Amendment rests on the assumption that the widest possible dissemination of information from diverse and antagonistic sources is essential to the welfare of the public, that a free press is a condition of a free society. And surely a command that the government itself shall not impede the free flow of ideas does not afford non-governmental combination a refuge if they impose restraints upon that constitutionally guaranteed freedom. Now, that's not to say that the First Amendment prohibits media companies from, that is, non-governmental combinations, from imposing restraints on freedom, on how ideas get communicated more generally. That is, those non-governmental entities have their own freedom to make decisions about how ideas get communicated. But the question is, if those non-governmental entities decide to form a monopoly or something that looks like a monopoly and restrict freedom of speech, how much can the government step in those circumstances in order to encourage more freedom of speech against that kind of private monopoly power? And Black says the fact that those media companies are media companies does not insulate them from that kind of governmental intervention. The government can intervene here with a goal of trying to break down those monopolies, open up more channels of communication without worrying that in doing so, they're violating the freedom of the press rights of those media companies. And that's true of these traditional media companies like the Associated Press, for example, which was a wire service that communicated with newspapers. And so the concern was that the Associated Press was creating contracts with newspapers and with reporters that was shrinking the space for individual reporters to report news and shrinking what newspapers could report. And so the government was concerned with interfering with how the Associated Press was forming those contracts between reporters and newspapers. So there, the concern was a kind of media monopoly that was affecting newspaper reporting. But that could apply to social media companies as well. So there's a concern that Facebook, for example, was a kind of monopoly and was restricting speech as a consequence of its monopoly power. The court has already said that the fact that Facebook might be regarded as a media company and as a consequence have some protections under freedom of the press, that does not insulate it from that kind of antitrust action designed to break up that monopoly private power in the name of the government trying to open up new channels of communication that those non-governmental actors might be trying to close off. Likewise, we can learn something from how the court has thought about broadcast media. So with the rise of radio and television in the immediate post-war period, the question was, how much can government interfere with how that kind of broadcast media behaved? And in particular, the problem with broadcast media is the government gave licenses to broadcast media companies that allowed them to use particular airwaves. And this was necessary because there's only so many airwaves to use under the technology of broadcast media. And so government had to coordinate so that those broadcast media companies didn't interfere with each other as they were broadcasting on their channels. And so people would give, in effect, a monopoly license to use a very specific wavelength in order to broadcast their media. And so if government was going to regulate and provide those kinds of narrow monopoly powers, what kinds of regulatory interactions could occur consistent with the First Amendment beyond that? And among the things the government decided to do was to create what was known as a fairness doctrine and a right to respond doctrine for broadcast companies. So that is, it required that broadcast companies, whether radio stations or television stations, make their airways available for certain kinds of responses. And those media companies brought a challenge under the First Amendment saying, now the government's telling us what kinds of things we have to put on our airwaves, and this is a violation of the freedom of the press. The court in the case of Red Lion Broadcasting Company versus Federal Communications Commission, which was decided in 1969, said, no, it doesn't. And it doesn't because of the very specific technological nature of broadcast companies. That if the government couldn't require those companies to put certain kinds of things on the air, there was a real danger that station owners and a few networks would have unfettered power to make time available only to the highest bidder, to communicate only their own views on public issues, people, and candidates, and to permit on the air only those with whom they agreed. There is no sanctuary in the First Amendment, the court concluded, for unlimited private censorship operating a medium that is not open to all. But the important point here is that this was a specific function of the kind of technology that broadcast media required. That it's because the broadcast media required these specific monopolies on the airwaves that allowed the government to have more regulatory authority in that context than they might have in a different context. And we can see that in the example of print media. So Miami Herald Publishing Company versus Tornillo, decided just a few years later in 1974, involved a similar kind of rule that was trying to be applied to a private newspaper. Here the concern was, could the government require a private newspaper to allow government officials, for example, or politicians, to have a right to respond in the pages of the newspaper? So if a politician did not like what a newspaper had said in its editorial, for example, could the government require that the newspaper provide space on its pages for that public official to respond to the editorial in the same newspaper? That is very similar to the kind of access to public airwaves that the court had been deciding in Red Lion, where the court had said, in the context of broadcast media, when we're talking about radio and television stations, they in fact can have that kind of requirement. The government can tell those broadcast media, you have to allow somebody on your airwaves under particular circumstances, because otherwise there's no access to those airwaves at all. But the court thought that was not true of print media. A newspaper, the court said, is more than a passive receptacle or conduit for news, comment, and advertising. The choice of material to go in a newspaper and the decisions made as to limitations on the size and content of the paper and the treatment of public issues and public officials, whether fair or unfair, constitute the exercise of editorial control and judgment. So a newspaper made decisions about what it wanted to say on its editorial page. And among those decisions are things that it did not want to say on its editorial page. And so if the newspaper wanted to criticize a government official on its editorial page, it could also make the decision not to allow a response from that government official. The government official could go someplace else to make their response available. So given the particular kinds of technology that print media represented, newspapers, the government could not interfere and say, you have to allow certain kinds of content to be available here. That broadcast media like radio and television was different than print media in this regard because of the nature of the technology, and different kinds of First Amendment rules applied as a consequence about who had to be allowed into that media space. Likewise, we can find even in a non-media space similar kinds of concerns. So this case arose, Hurley versus Irish American Gay, Lesbian, Bisexual Group of Boston, in the particular context of a parade on St. Patrick's Day. So parade organizers said they didn't want to include certain kinds of participants who wanted to participate in the parade. The Irish American Gay, Lesbian, and Bisexual Group of Boston in particular wanted to participate in a pre-organized Irish American parade. Those parade organizers said, we don't want that particular message as part of our parade. We want to exclude those individuals. And the question is, do they have a First Amendment right to exclude those individuals from the parade? And the court said that they do. As the court said in that case, decided 1995, since all speech inherently involves choices of what to say and what to leave unsaid, one important manifestation of the principle of free speech is that one who chooses to speak may also decide what not to say. So the government can't require parade organizers to convey messages and carry messages as part of their parade that the parade organizers do not want to convey. You cannot force the parade organizers to engage in speech they don't want to engage in. So that's similar to the principle that was at stake in the Miami Herald case. Similar kind of principle, you can't force the newspaper editors and publishers to carry messages they don't want to carry in the pages of their newspaper. Things like parades and newspapers are different than things like broadcast media because they don't exercise that kind of monopoly control of the airwaves that broadcast media operated. And as a consequence, the kind of right to carry that exists in that context did not exist in these other contexts. You had the right to exclude people from your platform in this context. And that has clear implications for thinking about social media companies. Are social media companies more like broadcast media? Are they like radio stations and television stations, such that the government can tell them you have to include certain kinds of content on your platform? Or are they more like newspapers and parades, where the government, because of the First Amendment, cannot impose that kind of requirement on those social media platforms and say you have to carry certain content that you don't want to carry? And the court, as we will see in a moment, has essentially said social media companies are more like parades and newspapers. They do not have the special technological implications of things like broadcast media. And as a consequence, social media companies should get to choose what kind of content they want to host on their platforms and what kind of content they do not want to host on their platforms. But social media companies are particularly regulated in ways that are unusual and are a function of their own kind of technological content. And this has become increasingly controversial over time. But it makes sense to start at the beginning as to why social media companies are regulated in this particular way in the first place. And this arose as a question of, are social media companies, or more broadly, computer networks, platforms that are liable for the content that they host? So this arose quite early in the internet age. This arose in a New York case decided in 1995 that was simply decided at the trial court level. It did not advance through higher levels of appellate review, and it emerged long before the modern internet as we know it, and certainly before social media companies as we now think of them first emerged. But Prodigy Services, which was an early internet company, provided access to people to post on what were at the time characterized as computer bulletin boards. So they could post messages for others to see on these so-called bulletin boards, which share many of the same characteristics as modern social media companies. But the challenge for Prodigy was, if you allow people to post on your bulletin boards that other people can read, were you therefore a publisher of what was being posted on those bulletin boards? Because if you were a publisher, then traditional libel law said you were responsible, legally speaking, for what was being published. So if a newspaper publishes libelous statements, for example, on the pages of its newspaper, it's responsible for those libelous statements, even if the author of the statement might be an individual reporter or even a member of the public. So if a member of the public writes to a newspaper to publish a letter to the editor, and the newspaper chooses to publish that letter to the editor, the newspaper then becomes responsible for the content of that letter to the editor. So if that member of the public says something defamatory in that letter to the editor, not only is the author of the letter legally liable for that defamatory statement, but likewise the newspaper is legally liable for that defamatory statement, and you can sue both the author and the newspaper. And of course, people prefer to be able to sue the newspaper because the newspaper has deeper pockets than the individual author of the letter to the editor. So the question for Prodigy Computer Services is a similar one. Are they like a newspaper making choices about what kinds of things are posted on their bulletin board? In which case, if somebody posts something defamatory about you on a computer bulletin board, can you sue not only the person who posted that defamatory information, but can you also sue the computer company that hosts the bulletin board in the first place? And that becomes particularly challenging if you have rules like Prodigy did that allowed them to take some information off those bulletin boards. That is, they had content moderation on those bulletin boards. And so they made some editorial choices about what things were going to be allowed on the bulletin boards and what things were not. The New York court said, well, now you start to sound like a newspaper. You've made choices. You've made editorial decisions about what things are going to be on the bulletin boards and what things are not going to be on the bulletin boards. You are now a publisher making content moderation decisions. And if you're going to be a publisher making content moderation decisions like a newspaper, you are legally liable then if somebody makes defamatory statements on those bulletin boards. Well, the consequences of that in a social media context are particularly grave. So the concern of Prodigy and likewise later internet companies that emerged to say, look, we're not like a newspaper with letter or the editor page because the volume of materials that we deal with is so gigantic. We can't possibly have an effective content moderation policy that would keep off all defamatory materials. And so if you're going to say that we're going to be liable for any defamatory materials that somebody might post on our bulletin boards, the consequence is either we're going to have to shut these things down entirely, or we're not going to have any content moderation at all. So we can't be like the newspaper to say we're going to pick and choose what gets posted, or we're going to take down certain things that get posted. Instead, we're going to be a passive conduit. We're just going to let everything get posted. And as a consequence, we're not going to be responsible if defamatory content appears there. Only the poster is going to be responsible for the defamatory content that gets posted there. Congress responds to this by saying, well, that sounds like a terrible idea. We want these kinds of computer networks to be able to engage in some content moderation, because content moderation will make them more useful. Content moderation is better for the public in general, but they're not going to engage in content moderation if they can be sued if anything slips through that happens to have defamatory content. So we need a set of regulatory policies that will immunize those social media companies or internet companies more generally from that kind of legal liability when they engage in content moderation. And it's as a consequence that Section 230C is born. Section 230 regulates the internet and regulates in particular what becomes known as social media companies and provides them with immunity from legal liability if they engage in content moderation and as a consequence are a publisher in that sense. So they're making choices about what things are going to be allowed on their network and what things are not going to be allowed on their network. But if they happen to have stuff on their network that falls in various kinds of categories, including defamatory speech, they are nonetheless not going to be responsible for that. Only the person who posted it is going to be legally responsible for it as a consequence. The goal here is to incentivize those computer networks, social media networks, to be able to engage in content moderation without having to worry that they've now opened themselves up to legal liability anytime something happens to slip through. So as the US Senate describes this in committee report, when passing the Communications Decency Act of 1996, which is what includes Section 230, this section provides so-called Good Samaritan protections from civil liability for providers or users of an interactive computer service for actions to restrict or enable restrictions of access to objectionable material online. The specific purpose is to overrule this New York case and any other kinds of similar decisions that might emerge, because the goal here is to make those media companies immune from the possibility they're going to be subject to libel suits while allowing them to engage in content moderation, which allows then social media companies, as we understand them, to operate more generally. So now that you've created that kind of regulatory framework, though, where the government has already stepped in to some degree to try to create a regulatory environment in which social media companies can arise, in which they are going to allow massive numbers of people to post things on these social media networks, but they're also going to have some content moderation. What else can the government do consistent with the First Amendment to help manipulate that content moderation set of policies? And increasingly, the government has become interested in trying to interfere to some degree with the content moderation policies that those social media companies have adopted. So some states, for example, have adopted policies designed to put a thumb on the scale of social media content regulation. This was recently brought to court with a First Amendment challenge by those social media companies, arguing that they had a right under the freedom of press to make decisions about what things will be and what things will not be posted on their networks. So much like the Miami Herald case, where the concern was, look, we have, as a newspaper, editorial control over what we want to say and what we don't want to have said on our platform. And we have a First Amendment right to exclude certain things that we do not want posted on our particular platform. And the states in this case, state of Texas, for example, by passing the social media law, says, no, we as a government ought to be able to regulate you and decide what kinds of content moderation policies you're going to have. The court didn't get to the final answer to that question in that particular case, but it did give a very clear hint and direction about how to think about this issue, which is to say the social media companies have a First Amendment right to exclude certain kinds of speech from their platforms, and governments cannot come in and manipulate their content moderation and require them to include content that they don't want to include. So as Justice Kagan said for the court, a state may not interfere with private actor speech to advance its own vision of ideological balance. If states are worried that certain kinds of speech, conservative speech, for example, is not being allowed on the platform, the state cannot come in and tell Facebook, you have to include more conservative speech on your platform, because Facebook has a First Amendment right to exclude that speech if it wants to. that Facebook is not like a broadcast television station in that sense. It is instead more like a newspaper and can make those kinds of editorial judgments on its own, free from governmental interference about what that looks like. There's also a question, though, about disinformation or misinformation on social media platforms. So if social media platforms allow not just, for example, libelous speech, and not only do they make decisions about how much conservative speech or how much liberal speech to allow on their platforms, but they want to exclude false speech from their platforms, what are the rules surrounding false speech that's not necessarily libelous speech? And in fact, there is a category of speech that we might think of as being false, that is, it's factually untrue, but is not libelous. So for example, it's not directed toward an individual. Libelous speech is false speech that injures a particular individual, is aimed at a particular individual. It's saying false and malicious things about a person. False speech might be simply untrue, but it's not aimed at any particular individual. It doesn't injure any particular individual as a consequence of this. This does not arise very often, but it did arise in a case in 2012 called United States versus Alvarez, where the court was confronted with the so-called Stolen Valor Act, which is a law that was designed to deal with people who falsely claimed that they had won military honors and medals from the government. And Congress wanted to criminally penalize people who made those claims, that is, made stolen valor claims. They claimed they had won a military honor when they in fact had not won a military honor. But this was not libelous speech. It didn't injure anyone in particular. And it wasn't necessarily fraudulent speech. That is, you're making false claims in order to extract something from somebody. You're trying to sell them something, and so you're making false claims about your product, for example, is simply false speech in general that does not immediately harm anyone by saying it, although it may be a social harm of devaluing, for example, military honors. The court says that kind of false speech is constitutionally protected. You're allowed to say false things in public, unless they fall into one of these very specific categories about what kind of false things might do injuries. So as Justice Anthony Kennedy said, in this case, our constitutional tradition stands against the idea that we need an oceanic ministry of truth, where false claims are made to effect a fraud or secure monies or other valuable considerations, say offers of employment. It is well established that the government may restrict speech without affronting the First Amendment. But the Stolen Valor Act, for example, is not limited to that. And if we allow the Stolen Valor Act, where the government just says these specific false claims that you make can be punished, then in fact the government could make all kinds of claims and could punish all kinds of speech in which you might say false things, and the government could punish it. And here the concern, Kennedy says, is that that kind of power, the mere potential of that kind of power, could cast a chill over speech more generally. This has big implications for thinking about misinformation on the internet. So if the government can regulate false claims generally, such as with the Stolen Valor Act, then they could clearly go after false claims on the internet broadly. So for example, if you make false claims about the efficacy of vaccines on the internet, if you make false claims about the nature of COVID on the internet, then the government could regulate that kind of speech because it's false. It's that kind of misinformation broadly. United States versus Alvarez says the government has no capacity to regulate and prohibit misinformation as such. And that then has, of course, specific implications for thinking about social media companies. So social media companies can choose, we don't want that kind of false speech on our platforms, because social media companies are private actors and they're not bound by the First Amendment. They don't have to allow false speech on their platforms if they don't want to, as we've seen already. But the government is constrained by the First Amendment. And Alvarez says, the First Amendment says the government can't prohibit misinformation of various sorts. Well, what if the government goes to a social media company and puts pressure on the social media company to exclude that kind of false speech? So the government doesn't like misinformation. It goes to the social media company and says, we would like you to take down that misinformation off your platform. Can the government do that? The court again was confronted with that case quite recently, in which a set of state governments brought suit against the government and the social media companies, arguing that the White House in particular had been putting pressure on social media companies to take down certain kinds of content that the government regarded as misinformation off of those platforms. And because of the nature of the suit, the court did not get to the substance of the claims, but as Justice Alito emphasized in dissent in that case, because he thought that the court should have gotten to the substance of those claims, there's a real concern here. As Alito says, the officials wielded potent authority. Their communications with Facebook were virtual demands, and Facebook's quavering response to those demands showed that it felt a strong need to yield. That is, the White House called up Facebook. They demanded that certain things be taken down off of Facebook. Facebook had an internal conversation about it and then removed that material from the internet. The concern of the court is to say there are going to be circumstances like that where government officials might put pressure on private entities to respond to their demands to take down information that the government itself cannot regulate directly because it's First Amendment protected, but might try to regulate indirectly by pressuring social media companies to remove that information. And the court has argued that at least in some circumstances, that's a violation of the First Amendment. The government cannot do things indirectly that it can't do directly. But it's very challenging to know, well, when is the government putting improper pressure on social media companies, for example, and when is it simply trying to persuade social media companies? So in this case, for example, the White House argued, well, look, we weren't putting pressure on the social media companies. We weren't coercing the social media companies to do what we wanted. We were simply pointing out to them that there was some information on their platforms that violated their pre-existing content moderation policies. We were not trying to change their content moderation policies. We were just calling attention to how their content moderation policies ought to be applied. And so as a consequence, we weren't putting pressure on these companies. And as a consequence, we weren't doing anything to violate the First Amendment. This is often the challenge in these kinds of cases. When is the government putting improper pressure on a company to try to take down materials? And when is the government merely trying to persuade or provide information to media companies that they might react to and respond to? And this is going to be a challenge for the court and for the government moving forward, because the government is going to continue to want to talk to social media companies about how they engage in content moderation. But the court has said that it's okay to talk to social media companies, but it's not okay to pressure social media companies, because the government is constrained by the First Amendment not to get the social media companies to do things the government itself cannot do through the First Amendment. So where does that leave us? What does government regulation look like on social media, and what does the First Amendment have to say about it? Well, first off, of course, social media companies can engage in content moderation. They're private companies. They're not bound by the First Amendment. They can make their own decisions about what they want to include on their platforms and what they want to exclude from their platforms. But engaging that kind of content moderation might make them legally liable for published content. The alternative is going to be not to engage in any content moderation at all, to simply act as a so-called passive conduit in which everything that somebody wants to post just gets published. Social media companies exercise no moderation content at all. But if they do exercise content moderation, there's a possibility they'll be treated like a newspaper and as a consequence might be legally liable for what somebody posts. Section 230, as long as it's in place, immunizes those companies from that kind of liability. It facilitates and allows them to engage in content moderation without fear that they may be subject to legal liability for things that slip through the cracks and get published on their platforms. So under current circumstances, they can engage in content moderation and not face that problem, that they might be subject, they might be have some legal liability for things getting published. But under those circumstances, then, what more can the government do to affect what kind of content moderation policies social media companies might adopt? And here the court has said it's okay to encourage social media companies to have a content moderation policy, which is what Section 230 does, but it's not okay for the government to try to dictate the content of that social media policy. So as a publisher, social media companies have a First Amendment interest in their content moderation choices. Facebook and Twitter can choose to have different kinds of content moderation choices, and the government cannot come in and say, I don't like the particular content moderation choices you've made. I want you to have a different set of content moderation choices and interfere with that kind of content moderation. That would violate the First Amendment rights of Facebook and Twitter, for example, to act as a publisher to make those choices about what things they want to have on their platform and what things they do not want to have on their platform. And the government can't do that directly by passing statutes that require that they have a different content moderation policy. And they can't do it indirectly by putting improper pressure on social media companies to modify their content moderation policies or their content moderation enforcement to be more consistent with the preferences of existing government officials.